Welcome back, dear learners. In the previous video, we saw the various types or modes of winding up. This video features on the process of winding up and the role of official liquidator in this process. So, let us get started. You already know that there are two types of winding up, namely voluntary winding up and winding up by tribunal. Let us see the process of winding up for each of these types separately. So, we will start with the process of winding up by the tribunal. In the previous video, you have already learnt about the circumstances in which a company may be wound up by a tribunal. Let us now see who can file a petition to the tribunal for the winding up of the company. According to section 272, subsection 1 of the Companies Act 2013, a petition to the tribunal for the winding up of a company can be presented by the company or by any contributory of the company or by the registrar or by any person authorized by the central government. Once the tribunal receives a petition for winding up under section 272, then it can pass any of the orders. First, the tribunal can dismiss the petition. Second, tribunal can make an interim order as it thinks fit. Third, tribunal can appoint a provisional liquidator for the company till the making of winding up order. Fourth, the tribunal can pass an order for the winding up of the company with or without costs. So, if the tribunal decides to wind up the company, it will immediately appoint an official liquidator who will look into the affairs of the company till it is dissolved. When a petition for winding up is made to the tribunal by any person other than the company, the tribunal will order the company to submit its objections along with the statement of affairs within 30 days in the prescribed form. The tribunal may grant an additional 30 days in special circumstances. Tribunal may also require the petitioner to deposit security for cost before issuing any directions to the company. If the company fails to submit the statement of affairs, then the company will lose the right to oppose the petition and the responsible directors and officers will face penalties. Section 273, subsection 1D gives the tribunal the power to order winding up of a company. When the tribunal orders winding up under section 273, subsection 1D, the directors and officers of the company must within 30 days submit audited books of accounts to the tribunal. If any directors or officers of the company are found violating these rules, then they may face imprisonment up to 6 months or a fine between 25,000 to 5 lakhs. Also, complaints regarding non-compliance can be filed before the special court by the registrar, provisional liquidator, company liquidator or any authorized person appointed by the tribunal. Now, let us look at the company's liquidators and their appointments. According to section 275, for the purpose of winding up of a company, the tribunal at the time of passing the order of winding up shall appoint an official liquidator. The tribunal may appoint a provisional liquidator amongst the insolvency professionals which are registered with the Insolvency and Bankruptcy Code 2016. If a provisional liquidator is appointed, the tribunal may restrict his powers. The tribunal will specify the terms and conditions and the fees payable to the provisional liquidator. Once a liquidator is appointed, he shall file a declaration within 7 days from the date of his appointment, disclosing conflict of interest or lack of independence with respect to the appointment. Upon receiving the copy of the order of appointment of a provisional liquidator or winding up order, the registrar shall make an endorsement in his records related to that particular company and notify the official gazetteer that such an order has been passed. Then a winding up order shall be passed. This winding up order will be considered as deemed to be notice of termination for the officers, employees and other workmen of the company unless the company's business continues after the order. Now, within 3 weeks from the passing of the winding up order, a winding up committee to monitor liquidation will be formed. This winding up committee shall consist of an official liquidator which is attached to the tribunal or nominee of secured creditors and a professional nominated by the tribunal. The company liquidator will convene the meeting of the winding up committee. The winding up committee will take over all the assets of the company. It will examine the statement of affairs of the company and review all the audit reports. The winding up committee, which is headed by the liquidator, will start the selling of the assets of the company. The committee will also finalize the list of creditors and contributories. The committee will look into the past payment of dividends and all the other settlement of claims. The company's liquidator will submit monthly reports to the tribunal. This report will contain the minutes of the meeting of the winding up committee which took place on a monthly basis. This report should be duly signed by all the members who were present during the winding up meetings. The liquidator shall compile all the reports and submit a final report to the tribunal related to winding up. Now, let us see what is the effect of winding up order. According to section 278, the order of the winding up of a company is treated as if it were made on a joint petition by both the company's creditors and contributories, and it takes effect for the benefit of all of them. Now, let us look at the process of voluntary winding up. You have already learned the meaning of voluntary winding up. You also know that in voluntary winding up, the members or creditors of a company volunteer to wind up the company by making a declaration of winding up. Once such a declaration is made, then within 4 weeks of this declaration, a special resolution of the members of the company has to be passed in the general meeting. The resolution should be related to voluntary winding up and it should appoint an insolvency professional who will act as a liquidator. The company will then notify the registrar of companies and the board about the resolution to liquidate the company. This intimation to the registrar of companies should be made within 7 days of passing the resolution. After that, a liquidator will be appointed and then the process will be the same as it was in the case of winding up by tribunal. As I told you in my previous video, do remember the important point that voluntary winding up is dealt as per the Insolvency and Bankruptcy Code of 2016. Please check out the website of the Ministry of Corporate Affairs. Look out for the winding up process, types and the Insolvency and Bankruptcy Code of 2016 over there. So, with this, we come to the end of this video. Hope you had a good learning. Thank you.